Let the record reflect that County Court at Law number 2 is now in session. Court is in session and cause number 319690. The case is styled the State of Texas versus Alan Rosemore. Let the record also reflect that Mr. Alan Rosemore is present in court with his attorney, Mr. Ryan Matuska. Let the record also reflect that the state is present with Assistant District Attorney Blake Ham and Attorney Andrew Huber. We also let the record reflect that the jury panel is in court. State, are you ready?
State ready.
Defense, are you ready?
Sir, Your Honor.
Okay. First of all, ladies and gentlemen, I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been called for jury duty for this week. You will be examined for inclusion on a jury hearing a criminal case. Our courtroom hours vary from 9 a.m. to 5 p.m., Monday through Fridays. Whether you are selected as a juror today or not, you are performing a significant service, which only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which requires a careful and correct trial. If selected on the jury, unless instructed otherwise, you will be permitted to separate at recess, for lunch, and at night. I have an administrative matter that I must attend to before administering to you the first of 2 oaths. Now, ladies and gentlemen, I know if you look at the monitors, you'll see the word live on YouTube. Pursuant to Article 1.24 of the Texas Code of Criminal Procedures, all proceedings and trials are public. That is, the defendant is entitled to a public trial. And because of our COVID protocols, we are mandated and required by the state of Texas to have our proceedings on YouTube because individuals cannot come into the courtroom. Normally, we would not have it on YouTube because the courtroom would be open, but since the public cannot have access, they will have access via YouTube. Now, I need each and every one of you to raise your right hand and I will administer to you an oath. And at the end of the oath, everyone please say, I do. You and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under directions of the court, touching on your service and qualifications as jurors, so help you God. Please say I do. Okay, you may put your hand down. The law requires that each of you must possess certain qualifications before you may be considered for service on a jury. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, I will ask you a series of questions, but I do not want you to answer out loud. Just answer to yourself. And at the end of the series of questions, I will ask, is anyone disqualified under the law? And if you think, based on your answers to the questions, that you may be disqualified under the law, please raise your right hand, and I will ask you to come up before the bench, and then we will discuss that matter privately. And the way we will discuss it, we will have this noise that's on so that no one will be able to hear what is being discussed. So my first question is this: except for failure to register, are you a qualified voter in Jefferson County and in the state of Texas under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, this is a question that I always tell people that I have to ask. It's a requirement, so do not take the question personally. Are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? Now, is anyone disqualified under the law? If you think that you may be, just raise your right hand. Let the record reflect that none of the panel have raised their hands. Now we will move on to exemptions. And I will determine if any of you who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, please continue to remain seated. Now, I will ask the questions in the same manner that I asked the first set of questions when we was trying to determine whether or not you were qualified. First question: are you over 70 years of age? Do you have legal custody of a child or children under the age of 12 years, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher learning? Are you an officer or employee of the state, the House of of the state Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the three-year period before today's date? Or are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Or you're a member of the United States military forces serving on active duty and deployed to a location away from your home station and out of Jefferson County? If any of these exemptions apply to you and you do not desire to serve as a juror, just please raise your right hand. Let the record reflect that no one has raised their right hand. Now I will move on to excuses. If any of you feel there is a reason why you cannot sit as a juror, then once I finish with the excuses, we will ask that you will raise your right hand and then come up before the bench. A juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the defense and the state. A juror, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone in the panel who will be exercising an excuse? If you are, please raise your right hand. Let the record reflect that no one on the panel have raised their right hand, so therefore, all of the jurors are qualified. No one has claimed an exemption and nobody has claimed an excuse. Now, ladies and gentlemen, the jury has been impaneled. Now we will move on to what the law calls voir dire, and that is the defense as well as the state will ask questions of you. Mr. Ham, are you ready?
Yes, Your Honor.
And Mr. Matuska, are you ready?
Yes, sir, Your Honor.
Okay. Mr. Ham, the panel is yours.
Thank you.
And Mr. Ham, you'll have 25 minutes and the court will keep time.
Thank you.
You got it?
afternoon. Thank you for coming and in the wind. I went outside once today and it seemed pretty stout, so thank you for coming out. Used to be, when I got here in July, it used to be that they'd do all the jury and gambling downstairs for all the courts at one time, and everyone would get a speech where you would all be thanked for coming. But you didn't get that speech, so thank you for coming. Because your job, if you're picked as a juror, will be to decide whether the defendant in this case, Mr. Rose, is guilty or innocent of the crime of which he's been charged. Your job. And it's my understanding that additionally, if the jury, whoever's on it, decides that Mr. Rosemore is guilty, he would also be responsible for deciding what his punishment would be. So, again, my name is Blake Ham. I'm a misdemeanor prosecutor for Jefferson County. Bless you, Mr. Porter. This is Andrew Hugel. He is also a misdemeanor prosecutor here in Jefferson County, so we work for you. This is my boss, Ray Shearer, who's taking notes and will evaluate you after this. So, word ire. What is word ire? In French, it means speaking the truth. This is the only opportunity that the attorneys in this case, myself and Mr. Matuska, will get to talk to you until the whole thing's over. So it's our job at this point in time to try to identify and find the best 6 jurors for this particular case. And has anybody been on a jury before? Well, yeah. Let me ask you, Carter, has anybody been to jury service before? Okay, so the majority of the people in this room have done this, and you've had this speech before. For those of you that haven't, it is well recognized by all of us that everyone comes in here with your own experiences and your own backgrounds and your own upbringings and that all, and their own ideas. Okay. And we're not here to say anybody's wrong or right in any of their beliefs. But it is our job to try to find the best 6 people for this particular case. Now we're in misdemeanor court, so thank goodness the crimes aren't typically as serious as those you would find in felony court, and the trials aren't nearly as long. So we'll be asking you questions to try to do that. So please give us, like the judge said, your most honest answers. So this is our chance to talk. So speak the truth. Okay. The crime that Mr. Rosemore has been alleged of committing is called failure to identify while you're a fugitive from justice. Okay. We're going to go through the elements here real quick. Basically, you are accused of lying to the police while you had warrants for your arrest. Here are the elements. And this is our burden of proof. Okay, the state, as most people are aware, the burden to prove the elements of the crime is on us. So we have to prove that in Jefferson County, Texas, that Mr. Rosemore, on or about May 14th, 2018, intentionally gave a false name, residence, address, or date of birth to a peace officer, was lawfully detained him when valid arrest warrants were outstanding for that person. That's what we have to prove. And it's our burden to prove to you. It's not Mr. Rosemore's burden. It's not Mr. Matuska's. It's ours. Okay. So were the jury to find Mr. Rosemore guilty of that crime? It is a class A misdemeanor. Okay, so misdemeanors are broken down into A and B here in this court. A is the more serious misdemeanor, B is the less serious. So this is the range of punishment. Like at the max end, and there's like max end, top end, it could be a year in jail. Or a $4,000 fine. Or he can be given probation. Now, so here's maybe a first point to ask a question. Let me try to explain it like this. So we say it's a range of punishment. And what you have to be able to do as a juror is you have to be able to consider the full range of punishment. Doesn't mean you have to take one end or the other. You just have to be able to consider it. It's like going to the grocery store. You have to say, well, I can go to the grocery store, I can look at everything on the shelves. I'm not buying everything on the shelves. I'm taking that out. So given the nature of this crime, and the fact that it's a Class A misdemeanor, is there anyone who thinks they just couldn't consider this range of punishment? Or anyone who has any questions about it? Let me see. Mr. Britt, you think you can consider the full range of punishment? I'm sorry.
Naomi
Ben, do you think you could consider the full range of punishment? I mean, does a year in jail seem too much for this kind of crime to you? Okay, maybe. All right, you have to see the evidence. Okay, I understand. And is it Eiselstein? Okay, what about you? How do you feel about this? You're fine with that? Okay. Ms. Smith? Good? All right. Okay, is anybody not good? Or anybody have any comments or want to ask any questions about this? All right, moving on. Again, you don't have to, if you're on the jury and you decide, okay, I'm going to vote guilty, you don't have to give me your jury. Okay, that's just the matter. So you can consider the full range. And that would be up to the jury. All right, so here's a big question. Has anybody ever seen that movie 12 Angry Men? No, maybe in school, you were made to watch it. All right, okay, beyond a reasonable doubt. Okay, it's a big question. What does it mean? Well, the courts have told us we can't try to tell you what it means. We can't define it for you. It's for every person to decide for themselves what beyond a reasonable doubt means. That, of course, is the level of proof that we have to reach to stay on each of those elements for you to vote guilty. And we have to prove each element beyond a reasonable doubt. What we can say is, it's not an impossible burden to meet. Can't find it for you. It's not an impossible burden to meet. You say use your common sense, whatever that means. It's your common sense, not mine. So whatever that means. So I had a bright idea, and I was going to show a clip. Has anybody not seen Indiana Jones? Raiders of the Lost Ark? Everybody's seen it. Everybody know who Marion is? Who's Marion? That's right. That's Indiana Jones. That's a girl, right? Yeah. So what I was going to do, and I wasn't technologically savvy enough to do this, was so there's a clip. There's a lot of chase scenes in that movie, right? One of the chase scenes, Marion is running around some Middle Eastern town or something, and she runs in through a darkened door, and you hear a clang, right? And then you see this dude, this bad guy, stumble out and fall down, and then Marion walks out with a frying pan, right? So we don't know what happened in that room, but we have a pretty good guess. Miss Clayton, what do you think happened in that room?
Well, you can determine from that frying pan that maybe she comes in, possibly.
That's
Don't
possible.
know. Possible.
Possible.
Don't know.
Right? What else could have happened? I don't know. Right?
It could have been the other way around too.
Could have been the other way around. What we do know, okay, if that was all the evidence that was given to you, right? Okay. So that's all the evidence that's given to you. Would there be any reasonable doubt in your mind that Marion playing that guy with a frying pan? Ms. Gordon?
You don't know. I mean, you don't know if you did something and you heard that. What was that?
That's right.
I don't know.
You don't know.
No,
You say if that's all the evidence there was, you don't think the state could prove?
no, I don't.
You don't? Okay. Well, what else do you think might have happened? You heard the sound of a frying pan hitting someone?
Yeah, no. You say it hit somebody. It could have hit the wall. She could have hit it on something else, trying to get out of the room.
Okay. That could, it's not enough for you. All right. Fair enough. Fair enough. Mr. Hamilton? Mr. Hamilton, what do you think? Would that, if that was our evidence and we were charging Marion with assault on a bad guy, right? And the evidence is that clip, bad guy runs in, you hear a clang, Marion walks out with a frying pan. Would there be any reasonable doubt in your mind that Marion had hit that guy with a frying pan? There would be. And why is that?
Because it's not conclusive. There's several other scenarios that could possibly affect the place.
Okay, and what kinds of things would you like to see to prove that beyond a reasonable doubt? What would be enough evidence for you?
A witness,
Okay,
photographic evidence, possibly an impression, supposed to say an impression of the bad guy's face on the frying pan, but then that still doesn't prove that he didn't run into it while it was hanging up inside the door.
gotcha. All right. Let's see. So you're thinking I need an eyewitness or photographic evidence for beyond a reasonable doubt.
In that case, yes.
In that case, there could be other things, right? Like you said, maybe there's an admission or something. All right, Miss, is it Fusilier? Fusilier. My apologies, Miss Fusilier. So what do you think? Would that be enough for you to convince you that Marion had whacked the guy with the frying pan?
Well, you would also have to look at the medical evidence as well. You know, you just can't assume that she hit him over the head with the frying pan, unless you actually, as several other people have mentioned, you know, saw it or evidence, or, you know, otherwise, you know,
I got you. Now, I'm not trying to pick on you guys, right, when I call you out, but we have to talk about it, all right? So you would like some other witnesses, or maybe some expert medical testimony about the injuries to the bad guy's face, right? Like maybe this is consistent, in my opinion, with being hit in the face with a frying pan from a woman of moderate strength and about that size, something, right? Okay. All right, I'm with you. Let's see, Mr. Dabney. Miss Dabney, what do you think?
I'm gonna use my common sense.
Okay.
Here's a scenario in the movie. She ran in this room, he ran after her, he was running after her. She took the frying pan, went clank, walked out with the frying pan in her hand.
Okay,
Little doubt.
little doubt. So that seems like that's beyond a reasonable doubt. Because placing the emphasis on the word reasonable. Like what are some other possibilities that might have happened, you think, in that room?
Was there someone else in the room and they hit him and gave the frying pan to her?
Could have been, right? But you don't have any evidence of that, do you? The only evidence you have is what I've described. And so to you, applying your common sense, you think beyond a reasonable. Okay, I got you. All right, well, okay, I didn't have that videotape for you. I'm sorry, it would make this more fun, but I'm gonna move on to this. So this, I'm trying to get rid of. My wife told me to use it. So this is another way that we try to sometimes explain beyond a reasonable doubt. It's the baby cake face thing. So, for example, on the left, you can see, okay, so beyond all doubt, the baby's face planted in the cake. Right, we see it. There's your photographic evidence, right? Caught on tape. Beyond all doubt, that baby is messing with that cake. Okay. And you look at the other side. We don't have the video or the picture of the baby face down in the cake, but we got the baby walking around with cake all over its face. Mr. Wilson. With that beyond a reasonable doubt, cake missing, baby covered in chocolate, would that be enough for you to say, if there was no other evidence, right? There's no other excuse, there's nobody coming in and saying, you know, well, I threw the cake in the baby's face, or, you know, that's all you have. Would that be enough for you to find the baby had eaten the cake covered?
I think if there was not a mixing hole around, lack of other evidence, yes, I would say that's probably what happened.
Fair enough, fair enough. Is it Mr. Perret?
Sure.
Perret. What do you think, Mr. Perret? Here's the state, we walk in, we want you to convict this baby, right? We're like, baby ate the cake. Here's the evidence, these pictures right here, that's what we got.
It's gonna depend how you line up the circumstances.
All right. You know, we're gonna get mom to testify, I made a cake, I put it on a table that was tall enough for the baby to get to. I left the room, I came back, and this is what I found. Here's a picture. Is that enough for you? No, not enough. What else would you want to see?
I don't know.
We don't know. Is it just hard for you because it's a baby? No? Okay. Good. All right. Well, so you get the point. Let me maybe circle back. Mr. Rule, right? How about the baby? Is that enough for you? Beyond a reasonable doubt? No. Not enough for you? Okay. All right. What would you want to see? To find the baby guilty?
I want to see what mom do that.
You want, okay. Well, let's
I want to be
say,
a witness.
okay, you need an eyewitness to this, not just some photographs. Okay, maybe a videotape. Yeah, right. All right. I got you. Ms. Smith, what about you? Think you can convict this baby?
No, I'll need more evidence, considering like you can see the hands, if there's like some cake underneath the fingernails, see that it dug into it, so.
So the cake on the face isn't enough. You're like, I need to see that.
Right.
I mean, but what if the story is the baby didn't use its hands, it just face down.
We need to see the face inside the cake, that look like a nice cake, so you can see the teeth there, yeah.
All right, I'll give you a look at the cake. Is this consistent? Are these bite marks consistent with this baby over here?
You could have pushed in there,
All right.
frame.
But you need more than just that.
Right.
If that's all you had, you're like, I don't know if that's got a reasonable doubt.
I mean, it's a possibility, but there's other things that make it, did the baby do it or somebody else did it to the baby?
I got you. It could have happened. Like I said, so what the point of all this is one thing we're trying to convey. That everybody's gonna have their own idea of this issue. It is maybe the major issue in any trial, right? For a juror, struggling with, what is this? I've seen the evidence. Is that enough for me beyond a reasonable doubt?
Mr. Ham, you have 10 more minutes?
How many?
10?
10.
Yeah.
So, and you have to weigh it in your head, but just remember, it's not beyond any possible doubt. That's not the standard. If that was the standard, it would be almost impossible to ever convict anyone for a crime, right? But this is the struggle that you're gonna have if you're picked to be on the jury. By the way, it's not really jury selection. It's more like jury deselection. Many of you are familiar with this. Some of you are. Who's never been on a jury or a jury panel? Never been on a jury panel. All right. So for your benefit, what's going to happen here is after I get done with my questions and Mr. Matuska's done with his, we're going to go back and we have this list. Looks like this. Everybody has their number, which is why the court was so particular about where you sit, right? Everybody has a number and name. And we're going to scratch. I get to scratch 3 off and he gets to scratch 3 off, and then whoever's left. Yeah, first 6 left. Yeah, you're right. There you go. So that's how it goes. All right, what else do we got? Oh, defendant's rights, of course. Super important to all of us. We're officers of the court. Mr. Rosemore, of course, has the 5th Amendment right not to testify. You can't hold that against the defendant. Okay? Is anybody here going to hold that against Mr. Rosemore? Like, you're like, man, if he doesn't testify in this case, I'm going to have a hard time, not finding him guilty. Is anybody? Good. Okay? Because he has a constitutional right not to testify. Not supposed to hold that against him. Remain silent. The right to counsel, Mr. Matuska. The right to a jury trial, which is what he's chosen. He is presumed innocent, right? So what is how does the phrase go? Innocent
Until proven guilty.
Okay, right. So that's a trick question because I saw this in felony court the other day and our judge was like, giving people a hard time. It's not innocent until proven guilty because until assumes that he will be proven guilty. It's innocent unless proven guilty. Okay. That's the actual phrase. You say until, that just presumes, well, at some point we're going to find him guilty. No, it's unless. Okay. Unless he's presumed innocent. There's been no evidence put before you. We have done nothing. At this point in time, this man is innocent. He has the right to subpoena witnesses, and he has the right to testify if he wants, but he doesn't have to. Okay, witnesses. Okay. Witness. See. Ms. Bex. Ms. Bex. If a witness is a police officer, for you, is that person going to start out with more or less credibility than any other person?
I think it's gonna be about the same. With, you know, maybe at first it would be more,
Okay.
but I would, you know, try to go with it with being about the same as anyone else that was testified. If that makes sense.
No, it makes sense to me. Now, you had mentioned that perhaps they would start out with more.
Yeah,
Okay, I mean, I have an idea why that might be, but
I'm sorry.
what's your reason for that?
Well, you know, you're supposed to, you know, look up to police officers, not really look up to them, but, you know, they're supposed to be law.
Okay. They're supposed to be, doesn't mean they are,
Right.
but they're supposed to be.
Right.
We hope they are. Ms. Sullivan,
Yes, sir.
how about you?
I would look at, him or her and follow.
I think that's the right approach. That would be my approach. Just because somebody's wearing a badge doesn't mean we hope they are, right? I mean, but it doesn't mean they are. They're just another person like you or me. So,
Stan, you have 5 minutes.
thanks, Judge. So all witnesses start off with the same credibility. We'll just skip over that. Not that it's not important, but I'll get 5 minutes. So take a look at this slide. And just take a second to think about which number you would, I mean, obviously, so it says number one. So it says, I believe law enforcement in our community is number one, not doing good enough. Two, they're doing a good job. Or three, they are way too overzealous in our community. Right now, this isn't going to fit anybody perfectly or in particular, right? But just if you had to categorize yourself. All right, Ms. Lane, what do you think?
I would say number two.
Number two, you're doing fine? All right. Ms. Britt? Two? All right. Ms. Vanmore? Two? Ms. Eisenstein? Two. All right. I'm gonna mess it up again. You told me this Fusilier. Fusilier. What do you think?
I don't know, I can go with two, like very nasty.
All right. Good enough for you. All right. And let's see. Let's go back. Let's go Ms. Harper.
I would think number two.
Number two. All right. Mr. Wolf.
I think they need number 4,
What's that?
use of authority.
Abuse of authority. Why is that?
I've been an Uber and Lyft driver for the last 3 years. I watched them flip on their lights to go through a red light, turn them back off. I see them speeding all the time. They're supposed to be enforcing the law.
All right, I agree with you. That's not right. Okay, good answer. All right, let's see, Ms. Smith. Two, Ms. Sullivan.
I would say number two for the most part.
Fair enough. Ms. Dabney. Two, Mr. Hamilton.
What is number 1? I can't remember.
Number one is they're not doing good enough. They need to step it up.
Number 2.
Number two. Okay. All right. Mr. Wood.
Number two, to keep it in mind, there's bad apples in every profession.
Agreed. 100%. We need internal affairs. All cops are perfect. All right. Let's see. Ms. Bacon. Good enough for you? All right, yeah. All right, good job, guys. Ms. Gordon? Two. All right. Let's see, Ms. Dex? Two. right, Ms. Wilson,
I'd go with two.
two, fair enough. There was gonna be Mr. Rotten, but he's not here. So, Mr. Harrod, two, all right.
Sam, you have 2 more minutes?
Got it. Thank you very much. I appreciate your time. Thanks for being here. We absolutely, it would be worthless without you. Because I can't decide if somebody's good or innocent, guilty or innocent. Neither can Mr. Matuska. It's going to be up to the citizens of Jefferson County. So thank you very much.
Okay. Mr. Toofer, do you need time to set up?
Yes, sir, Your Honor. Thank you.
Once you get started, you'll have 25 minutes as well.
25, yes, sir.
Yes, and I'll keep time.
That's the courts. You want to take it off?
No,
Does it work for you?
well, I don't have the issue on. Thunderbolt, thundercloud, change all that, something new. All right, Your Honor, I'm good.
Okay, Mr. Patuska, the panel is yours.
Mr. Hank? Morning, afternoon, what is it? Afternoon, I guess. We've been mixing this up a lot lately. Post-COVID, we're trying to get back to normal. This is actually one of the first months we've been back in the courtroom. I know we're still spread out, but as Mr. Ham said, we've been downstairs in that giant paneling room. And if you're number 70, I can't even hear you. I can't even see you. I have a good buddy who was on the last row. I didn't even know he was in the room. And we picked a jury after a couple of hours. He just never said anything. He was way low in the back. So as Mr. Ham said, thank you all for being here. I appreciate it also. And I know Mr. Rosemore appreciates it. We couldn't do this without y'all. Now, just to briefly introduce myself, I used to not do this, but more and more judges tell me I need to say something. So I've been practicing here in Jefferson County since 2007. My office is located in Nederland. Does anybody know my wife, Jamie Matuska, or my sister-in-law, Lindsay Scott? Anybody? Miss Gordy. How do you know one of us?
Well, I know Lindsay, because she's best friends with my boyfriend's daughter,
And that's,
Ellen Pettit.
oh, okay, all right. That wouldn't affect you at all if you were on the jury. Okay. And Ms. Scott's on my actual sign outside the highway, so some people always ask me that if we're still practicing together. She was a judge down in the 252nd for a while before Judge West.
And I also did a story on her, after she saw that, cleared those cases. I was working for Channel 6.
Oh, okay.
So that's how I first met her.
Yeah. Thank you. Anyone else? No?
I do.
Ms. Lane? Yeah. Coach baseball with us.
Yeah, yeah.
You live next to Bobovich, right? Okay. You know all three of us about maybe.
Yeah.
That wouldn't affect you at all?
No.
Okay. Thank you. It's my honor to be here today and this week, depending on how long this trial goes, on behalf of Mr. Rosemore. Now, I don't think any of us envy this chair that is next to me, but I would hope that all of us would treat that position here in the courtroom like we would our most loved one or even ourselves. And
So that's where I start. Why a jury? Why not just let the police, prosecutor, Judge Holmes decide? Mr. Britt, how about you? Why do you?
Be judged by peers. Be judged by peers.
Be judged by his peers. And what exactly do you mean by that?
Well, he has the right to state his case and we get to decide what we think.
Do you agree or disagree with any of these? These are all good reasons why basically we have our peers to judge us in situations where we're accused.
Yeah, they're,
Are there any that you would add?
no, good.
Good. Okay, thank you. Ms. Von Wart, I see that right? Would you add anything to that list? Checks and balances, corruption, protect your constitutional rights. Are those all valid reasons to you? Do you feel comfortable with just letting the police or the prosecutor or the judge decide and not having an option?
There needs to be that balance there. Because we can all be, when we're so involved in a case, we can become more unchanging. We might not see everything that there is. So sometimes we need an outside view to help on the journey of truth.
Thank you. That was a very eloquent. How about you, Ms. Knight? Do you agree or disagree with this?
I'm sorry, I
Gotcha.
missed a little bit of what she
You
said.
didn't think I was going backwards?
No, I did not. I was not ready.
I'll get any of you, don't worry. So, why not, well, how comfortable would you feel personally if we just said, let's get rid of the jury system? Let's just let the police, prosecutor, or judges.
No, and like somebody said earlier, there's a couple bad, there's always bad apples in every occupation. So I wouldn't want that for anybody.
I don't think any of us feel comfortable with that, do we? Anyone? We have a free country. We value liberty. We're all about people. And we don't know really any of you. Ms. Dabney, how does that make you feel? Just strangers.
Well, I would hope that they would put themselves in a position of both sides and make everything with fresh eyes. Because I'm sure one side's gonna say one thing, the other side's saying the other thing. You've got to weed through all of it.
Yes, ma'am.
Come up what we believe is the truth.
Yeah, it's good to see your face. I've talked to you on the phone many times for
Yeah.
garage door. You're always super nice. Thank you. We have rights, and some of us value some rights more than others, but I think we can all agree those rights are important. Once in a while, I volunteer at the schools in Neal and talk about Constitution Day, and they always ask what rights are. That's not an easy question. Ms. Salo, what rights are important to you?
Freedom of speech,
Freedom of speech. Why?
because I think everyone is entitled to say what they believe. They believe is true or factual. I don't think anyone should take that right away from something.
You know, I heard in multiple news outlets about Russian stories over there and throwing people in jail for saying what they feel, or maybe something that they didn't like. May not be right, but they still threw them in jail. How does that make you feel? Imagine if we lived in a country like that.
I think that's horrible.
Just to say whatever's on your mind.
Whatever, that's why I feel like that's an injustice. Everyone should be able to say how they feel without the feeling that they are going to be reprimanded or punished for saying what they feel. What they feel.
You feel like that's anti-government, or that's just freedom?
I think that's just freedom.
And That's interesting that you said that one first, because I find that terrifying. Just because you say something, or you're overheard saying something, could be construed. Definitely, right?
It could be.
Thank you. Mr. Hamlin, how about you?
There's a question.
Rights.
Second,
What rights are important to you?
freedom of speech, of course, freedom of movement, freedom of pursuit of well-being.
Thank you. Ms. Kuchler.
Well, our rights are important, but to me, the right to assume someone else's identity is not right. I know from experience.
Oh. Thank you. Ms. Eiselstein. That's it, right? How about you?
The right to freedom of religion
There you go.
and.
I'm glad I'm not the only one. Renegade went off, I thought, oh, no, this is it.
Freedom of religion, of course, the right to bear arms.
That's a good one too. I love those two very much. Thank you. So I appreciate all of you all sharing this. Sitting here today, Miss Lane, Mr. Rosemore, pick one of those, guilty, not guilty, or not sure. You don't know anything about the case?
Not sure.
Not sure? Ms. Britt?
I'm not guilty.
Not guilty. Ms. Barber?
Not sure.
Not sure. Ms. Eiselstein?
Not guilty.
Not guilty. Ms. Smith?
Innocent.
Ms. Wolf? Not guilty.
Maybe commission not guilty, not sure. Sure, but you have to bring the innocence first, because we haven't heard anything.
Ms. Kuchler? It just doesn't come out. Fusler, right? Fusler. I feel like I'm mispronouncing it every time.
It happens.
I'm sure you get, I give them two skill levels.
It doesn't matter. I don't think you want it.
Pick one of those.
Not sure.
Not sure. Thank you. Mrs. Stout?
Unsure.
Thank you. Ms. Devon?
Sure.
Sure. Ms. Ramsey?
Not sure.
Sure. Ms. Specs?
Not
Ms. Gordon?
Not sure.
Ms. Clayton?
Not guilty.
Mr. Ward?
Not sure till I hear both sides.
Thank you. Ms. Woods?
At this point, not guilty.
And Mr. Britt?
Not sure.
Not sure. Uh-oh. Who got it? Why is it not guilty? Presumption of innocence. And that, as Mr. Ham said, is unless or until. Unless, gotta pay attention. It's the only lawful authority needed for you to elect a fellow citizen not guilty. That's pretty powerful. Ms. Sal, how do you feel about that?
I agree with that. I mean, I think that everyone, that comes in a courtroom, is not guilty, and they have a right to, put me on the spot here. To be honest, I don't know how to answer that.
No, that's fine. That's fine. You're just speaking out of your field. I appreciate that. Mr. Britt, you kind of touched upon this a little earlier. And so how does that make you?
Yeah, he's proven guilty.
You kind of said it earlier, you know, you come in here, you're gonna go through it. Now, Mr. Ham has that duty to bring forth that evidence. And if you were sitting here next to me, would you want that?
Absolutely.
Anybody else I'm sure, in this room would want exactly that, right? The presumption of innocence lasts throughout the whole trial. And that's why you guys, whoever is picked on this jury, will go back and deliberate and decide based upon the evidence the government has presented. Now, if the government doesn't prove that, you all don't agree on that. Then we what? We say, sorry, you didn't go all the way over the line, right? Or, guess in football analogy, you didn't cross the threshold. According to the United States Supreme Court, an accusatory system requires the government in its contest with the individual to shoulder the entire load. Does anybody feel like that's too much? No, we all like that, right? We all feel comfortable with that, even though we could be potentially in a very uncomfortable accusatory system, right? Has anybody here been accused of something, maybe not a crime, that they were completely innocent of and had a difficult time trying to say otherwise, trying to prove? Anybody? I think we all have at some point, right? And it's frustrating. Ms. Clayton, do you understand where I'm going with that? That our government says you don't have to do that. Do you like that system?
Go back, say that again.
So
I don't.
we've all been accused at some point of something. It could be a speeding ticket, or it could be something small, could be something we did as a child. But is it a frustrating emotion to try to prove something when you're completely innocent?
Absolutely.
And can you express that frustration in words?
What's hard to, to get someone else to understand and accept the fact that I didn't say it, I didn't do it, and they already have that presumption in their head that, yeah, I believe you did it. So, at some point, I don't want to see how to let it go, but, that's something they have to do.
Very well said. Mr. Wood, do you agree or disagree with?
I like the way it states. I think that forefathers, everybody set the system up with geniuses.
I agree. It's a challenge, but I think they did it. Alan can sit here, listen, do nothing, present no evidence, invoke his right not to testify, and remain silent.
You have 10 more minutes.
Ms. Lang, how does that make you feel?
What, they didn't say anything? What do you-
Just sat here, said, not guilty. Now, you would still listen to Mr. Henry Evans,
Okay.
but just an American citizen doing that, how does that make you feel? A little uncomfortable, not uncomfortable?
Some people aren't good at getting their point across.
It's a very, did you see the next slide? It brings me to the next slide. Why, innocent reason why someone would not testify? Ms. Hartman?
They may have a stutter or a speech impediment that might make it worse on them, or they may not be adequate with their words. And so letting the lawyer speak on their behalf might be a better way to actually represent themselves.
That's, I couldn't express that better. Exactly. And let's see a show of hands of people that have been on the jury that actually deliberated. And we all come from different education backgrounds, right? We all have different ways to communicate and express ourselves. We may stutter, or we may be nervous. Is that a reason? But we all express ourselves differently. Has anybody here walked up and sat in that chair? Mr. Wolf? Never? Would you want to? Ms. Sutton,
Yes.
how did that feel?
It was I was nervous, but I answered every question that both attorneys asked me, and I answered it to my best of my ability.
Were you accused?
No,
Would that have been different, you think?
absolutely, because I get defensive. So, yes, sir.
That's a great point. I do too sometimes. And, you know, it's not sometimes viewed the same as how you think you're expressing yourself, right? Ms. Porter, did you raise your hand?
I did.
How did you feel?
You don't know if you said what you thought you were saying, or you.
I've heard some people say it's almost an out-of-body experience because you're listening to yourself at the same time. And long ago, when I was a law student, they threw me into a trial, and I kind of felt that way. And so I think back at that, but I've honestly never been. Thank you for sharing that. This is a sterile environment, so the judges are basically going to decide some issues on what a jury can't hear. And we are going to make this as fair as possible, but this is a different environment. Would you agree or disagree with this court? So, anybody here been stopped on the side of the road for a traffic violation? I know I have. How does that make you feel? Ms. Devon?
Stupid. I was guilty,
Stupid? Yeah.
sorry.
Ms. Bundle, how about you?
Definitely shameful.
Call me out.
Seeing those lights, having to pull over, especially at nighttime, not a good feeling, right? Ms. Smith, have you ever had that experience?
I just have to try.
Ms. Britt, have you? How did that make you?
It's not fun.
It's not. Even when you know you might have been a little over the limit, or maybe you didn't have your seatbelt on, or maybe you just don't know why. Ms. Lane, how did that make you feel?
It's not fun.
It's not.
Especially when your kids in the back seat will remind you about it all the time.
You get it over and over
Yeah.
and over. Mommy's a criminal.
Yeah.
Oh, I know. Anybody with life experiences in this type of case? This is a unique type of case. Most people don't, but sometimes we do. And innocent reasons why a citizen would be accused of this type of case.
5 minutes.
A little challenging. You're doing so good.
If maybe on the evidence didn't line up, maybe it leans more towards guilty than not guilty, and that when there's a hole and the jury didn't actually investigate the hole, they just went with it and moved forward. And so they had doubt in themselves, but they pushed through, and that person then was punished.
Thank you. Ms. Fusler. Did I do better? It's the third time, I'm gonna get it. I'm determined.
I would say, if the person is guilty of the crime, you know, and, I mean, there's no coming back from that.
Well, but innocent reasons why to be accused.
But there would be a number of reasons, you know, maybe all the facts weren't there, maybe, some of the information was there.
Now, this is a communication potential issue, right, Mr. Wolf? We're talking about communicating with a presumably police officer, right?
So what officer has to base what he does on the information he has on hand?
So we've got
So you
two
might go
people.
across somebody with physical description on what he was given. Of course, they're gonna question him. That don't make him guilty.
That's true. Thank you. Ms. Betts, how about you?
Well, I think that, yeah, there could be a lot of reasons, there's a lot, identity, but this is a different situation where, if he's told a police officer something, then it's their word against his. Pretty much.
So I'm gonna skip ahead because Mr. Wolf, there you are. Because Mr. Ham did a good job going through a lot of this already. I just want to go through these real quick. Mr. Ham touched upon this a little bit, but we do not define beyond a reasonable doubt. And that is very unique because some other courts and some other cases we do. Now, we have legal standards and we have 5 main ones here. Beyond reasonable doubt, I put at the top is the highest burden. The lowest, we have a reasonable suspicion. And this is a minimal level of proof for police to stop you on the street. Question you, ask you what's going on, but it must be specific
Mr. Ham,
reasons.
Ms. Matuska, you have 2 more minutes.
Thank you, Ron. More than just a mere hunch. Ms. Lane, you agree or disagree that we should be more than a mere hunch? You think police should need something?
Yeah.
Why is that?
I mean, if I'm doing anything wrong. There needs to be a reason that they're pulling you over or chopping you or, you know,
You don't like the idea of just, hey, come here.
makes me nervous.
How much proof is that to you?
What do you mean?
Just to pull you over, that they need to question you on specific reasons?
Like, what I need to be doing wrong?
Now, just how much proof do you think police officer needs?
You have 1 more minute.
That's a fair answer. Because the next one is probable cause. And that's the next step up. When an officer actually needs to arrest you. Should that be more? Ms. Lane?
Should that be more?
More than reasonable suspicion.
Yes.
The next one, we know this one from the scales, 51%. We know 51%.
30 seconds.
This one, Mr. Ham used baby cakes, is defined. In Texas, to take someone's child, you need to prove by clear and convincing evidence. And that's a firm belief that the allegations are true. And we have defined that. The next one, though,
10 seconds.
we have not defined. So, Ms. Dabney, is that just common sense? Or is that a higher standard?
Time is up.
Thank you. Thank you, Ron.
All right, you're welcome. Okay, ladies and gentlemen of the jury, we're gonna ask that you follow the bailiff back out into the hallway. Now, we may have to call some of you back in for the attorneys to do some follow-up questions. So do not venture too far from the hallway. will anybody be, exercising any, do y'all need anybody else to come in or do some follow-up questions, challenges, or calls?
No, sir. No, sir.
State and defense, okay. State, you're gonna use the conference room,
Yes, Your Honor, if that's okay.
and y'all